Good morning. Happy Tuesday. A certain constitutional law scholar made a video about Atwater versus the city of Lago Vista, a 2001 United States Supreme Court case. And he sensationalized certain aspects of it, but at the end of the day, the bare facts are as follows. The plaintiff in a 1983 lawsuit was driving a truck without wearing a seatbelt. Texas law required her to wear a seatbelt. A violation of that law was a misdemeanor, punishable by a fine. She had two children in the car, two children in the front seat of the truck, ages 3 and 5. Texas law at that time required children in the front seat to be in seatbelts, or else the driver of the vehicle would be committing a misdemeanor, punishable by a fine. So she was doing two things that were misdemeanors: driving a vehicle without a seatbelt on, two children in the front seat without seatbelts on. So a officer saw her, pulled her over. She said, "I don't have my driver's license and proof of insurance. My purse was stolen." So no ID, no proof of insurance. The officer decided to arrest her. Got her in front of a magistrate, booked her, i.e. identified her, positively identified her, got her in front of a magistrate. She got out on bond. She ended up pleading guilty to the seatbelt offenses, the seatbelt misdemeanors, and the other two charges, the driving without a license and the driving without proof of insurance, those were dropped. I'm assuming as part of the plea deal. That's normally what happens. So she sues. She sues the police because, oh my God, right? Oh my God, how dare you arrest me when I don't have proof of insurance or an ID to show you positively that I am who I say I am? How dare you? Even though Texas law authorizes the arrest for people committing misdemeanors. Specifically, Texas law authorized that officer to make that arrest. There's a statute in Texas that says police can arrest for seatbelt violations, moving violations that are misdemeanors. I haven't read the exact statute. Read the case. You'll figure it out. So that's what made it up to the Supreme Court. Was it a Fourth Amendment violation for an officer to make an arrest for a misdemeanor committed in his presence that did not have jail time associated with it? That's the question, which ultimately begs the question of whether or not Texas can authorize it. Texas is the one who made the statute saying the officer can do it. So does Texas have that power? Well, the Supreme Court looked at the history of whether or not police officers can make arrests for misdemeanors, going all the way back to ye old time England. And they found that yes, officers always could make arrests for misdemeanors. Even they were talking about like night watchmen being able to arrest night walkers, people who haven't committed any crime as far as anybody knows. They were just out after dark. And the night watchman could arrest them until morning. So, is it a Fourth Amendment violation? Specifically, does federal law make it unconstitutional? Does the federal Constitution make it unconstitutional for Texas to have a statute that authorizes police to arrest for misdemeanors that don't have a jail time associated with their commission? And the Supreme Court said, you know what? It's not a Fourth Amendment violation. Does that mean that Texas could do it? Yes, that means Texas could do it as long as it's consistent with Texas's constitution. Does that mean any other state could do it? Yes. In fact, there's an appendix in it showing that every other state, including the District of Columbia, has laws authorizing the arrest for people committing misdemeanors in the presence of an officer, of a peace officer. A couple states had exclusions to that, where it narrowed the ability of the officer to make the arrest, but every state had that ability for officers to make arrests for misdemeanors committed within his presence. So literally every state is doing it. It's been done forever since before the United States existed. These arrests have been made. Obviously, not for moving violations or for traffic or seatbelt infractions, because there weren't such things. But again, we're talking about misdemeanors that have no jail time associated with them. So it's not a Fourth Amendment violation. Now, a non-constitutional law scholar would be like, you know what? I think this is a problem. Because you know what? I don't like seatbelt violations. I don't like seatbelt tickets. I don't like seatbelt laws. I think that the state should have no business in telling you what sort of safety measures you should take. Next thing you know, the state's going to say you need to wear a condom because people getting sexually transmitted diseases cost the state X amount of dollars per year and blah, blah, blah. I mean, same logic applies. It's stupid. I don't like it. It's intrusive. Your mileage may vary and you're entitled to your own opinion. And I'm sure I'm going to hear it in the comment section. And I'm sure it's not going to change my mind, but you're entitled to say it. But a non-constitutional law scholar would say, you know what? There's two laws here in Texas that we could change that would, if done, eliminate this particular problem without making it a constitutional violation. We can, A, have the Texas legislature draft a bill and send it up to the governor to sign into law, removing the power of peace officers to make arrests for these misdemeanors that don't have jail time associated with them. Or number two, we can decriminalize seatbelt laws. We can make it so that it's not any business of the state whether or not you're wearing a seatbelt. Two ways, both of which would eliminate the problem that was encountered, or the problem that was encountered in Atwater versus the Lago Vista. Either way, that problem is solved, resolved, gone. So, constitutional law scholars should recognize that, number one, it's not infractions, it's misdemeanors. It was a misdemeanor. And number two, Texas law authorized it. If Texas law did not authorize the arrest for that misdemeanor, then we would have gotten an entirely different outcome from the United States Supreme Court. If Texas law did not authorize the arrest for that misdemeanor, then would it be a reasonable seizure? No, it would not. And all of a sudden there's a Fourth Amendment violation, or presumably there would be a Fourth Amendment violation. So, ta-da! What's going to be easier, overturning a United States Supreme Court decision that has now been established for 22 years approximately, or getting the Texas legislature to change what people can and can't be arrested for? What do you think would be easier? Also, this is a good thing to remind people to make sure that you carry your driver's license and proof of insurance. Because if police can't positively identify you, they may end up arresting you, taking you down to the police station to make sure they know who you are. Thanks for watching. Have a great day.